Hello and welcome everyone to the Drishti IAS English YouTube channel. My name is Pragya and in today's episode of Polity Primer, we are going to discuss a very important topic that is in news recently. We have also seen this topic known as governor versus government in our previous lecture, and this is an extension of that controversy that is going on. The title of our today's discussion is Governor's Power over State Bills. In this discussion, we will be studying about the governor's power over state bills. We will also see the constitutional provisions in this regard. We are also going to see the SCs or the Supreme Court observations in relation to this present controversy. And in the end, we are going to see a practice question for your prelims examination and a practice question for your mains examination. So if I talk about the background of our today's topic, recently a petition has been filed by the state of Punjab. State of Punjab in the Supreme Court, alleging that the governor is not giving assent to various legislative bills, and this in turn is hampering the administration in the state. So this is not the first time a state government is approaching the Supreme Court. Previously also the state of Telangana and state of Kerala. State of Telangana and state of Kerala have approached the Supreme Court alleging similar controversy. So we have also studied this controversy in detail in our governor versus government lecture, wherein we have studied that the governors do not have a timeline to give their assent to legislative bills and they keep sitting on the bills. So this time the Punjab government has approached the Supreme Court, and the Supreme Court has made very stern observations which we are going to see in our and study in our further slides. So firstly, let us understand the governor's powers over the state bill. So as you all know, a bill cannot become a law. A bill cannot become a law until and unless it has received the assent of president if it is a central bill, and it is a governor's assent if it is a state government bill. So for the passage of bill to become a law, assent is very important, and in this situation the governor is the chief executive of the state and his position is analogous to that of the President of India. So the governor has the power to give assent over the bills, but there is no fixed timeline under which he can give the assent, and that is why a controversy often arises that whenever the governor keeps on sitting indefinitely over the state bills, and this has led to even further controversy and the matter has already reached the Supreme Court. Now let us examine the constitutional provisions in this regard. So the constitutional provisions are Article 200, which talks about the governor powers to assent over bills, and Article 201, which also talks about the bills that are kept for reconsideration by the president by the governor. So Article 200 of the Indian Constitution outlines the process for a bill passed by the Legislative Assembly of a state. So whenever there is a bill passed by the Legislative Assembly of the state, the governor has two options: either to give the assent to bill or to send the whole bill or some provisions of the bill, for the reconsideration by the houses. He also has a option of withholding his assent, but this withholding of assent is not considered to be constitutionally true. It is not considered to be a good practice. Okay, so whenever there is a bill presented to the governor for assent, who may either assent, withhold his assent or reserve the bill for consideration by the president. And this reservation of bill for the consideration by the president becomes obligatory in nature whenever the bill in the state bill proposes some changes in the state high court. So this is just one circumstances wherein it is obligatory for the governor to keep the bill for reconsideration by the president. In all other circumstances, it is his discretion. But as there is no fixed timelines, definitely the governor can, refuse to give his assent or withhold his assent. Okay, the governor may also return the bill, as I was explaining to you before also, whole bill or some provisions of the bill for the reconsideration by the State Legislative Assembly, or if there is a State Legislative Council, then the State Legislative Council. Okay. Article 201 of our Indian Constitution states that when a bill is reserved for the consideration of the President may assent to or withhold assent from the bill. So what is this talking about? The governor has the power to, reserve the bill for consideration by the President, and if it happens, then it no longer is in the hands of the governor. The power passes on to the President of India, who in turn may withhold his assent or may give the assent, or may ask the State Legislative Assembly or the Council to reconsider the whole bill or some provisions of the bill. Okay. The President may also direct the governor to return the bill, as I have explained to you, to the house or houses of the legislature of the state for reconsideration. So, under Article 201, if the bill is reserved by the governor for the consideration by the President, then it is no longer in the hands of the governor. The power shifts to the President of India. Now, let us see what the Supreme Court has said. The stern remarks made by the Supreme Court in the case filed by the Punjab government. Okay, the Supreme Court expressed concerns while hearing the Punjab government's plea against the governor Banwari Lal Purohit's delay in giving a nod to the bills passed by the State Assembly. The Supreme Court has stated that the governors should do some soul searching. See, governor is the constitutional head of the state. Under Article 153, it is mandatory for the state legislature to have a governor. And the governor is also the, protector of the Constitution of India. The governor's post is also an important link for having cooperative federalism in India, because he is the central government's, representative in the state government. So, being on a constitutional post, and the governor should work for the welfare of the state, because he is the constitutional head of the state. He should not act like a mere puppet in the hands of the central government, and this has also been advised by various committees such as the Sarkaria committee and etc., which have examined the central state relations. So the Supreme Court is also saying so that if there is any dispute between the governor and the state legislative assembly, they should not come to the court. Court should be the last resort. It is not the function of the court to adjudicate these matters. You should resolve it within yourselves. So the Supreme Court also agrees that governors should do some soul searching, and they cannot indefinitely sit on bills passed by the state legislative assembly. What happens is, whenever there is an impasse between the state legislative assembly or the state government or the governor, then the state government can also ask the central government to invoke Article 355. When this Article 355 is invoked and supposedly the impasse has not ended, then the central government is empowered to impose precedence rule under Article 356 by stating that the constitutional machinery has failed in the state. So see what can be the consequence, how dire can be the consequence of this impasse between governor and the state government. So this should not happen ideally, and they should resolve their disputes amicably, as has been observed by our Honorable Supreme Court of India. The Supreme Court also said that the governors must act on the bills passed by the respective state assemblies even before the matter reaches to the Supreme Court of India. So see, the Supreme Court is very clear that it is not our business to adjudicate all of these disputes. Okay, you should resolve it amicably. The Supreme Court has also made some other observations in previous cases. So the Supreme Court has observed in another case. This case is State of Telangana wala case. State of Telangana case. So this is State of Telangana case. The Supreme Court observed that the bill sent to the governor for assent must be returned as soon as possible and not sit over them, causing gubernatorial procrastination and making state legislative assemblies wait indefinitely. So the Supreme Court has also made these stern remarks before also. But the impasse doesn't seem to be ending. The governors do keep on sitting on the bills indefinitely. And this is definitely causing a failure of constitutional machinery in the state. The state legislative assembly is very helpless because for a bill to become a law, you require the assent by the governor. Okay. While referring to the first proviso of Article 200 of the Constitution, the Supreme Court mandated that governor should not delay over bills sent to them for assent after they have been passed by the legislative assemblies. But it seems as though that this directive of the Supreme Court is blatantly violated. And this should not happen because we are a democracy. We have a democratic form of government. The governor is not the elected representative of the people. The state legislative assembly is. Okay. So that is why this this impasse should be resolved amicably between the state legislative assembly or the state government and the governor without the constant interference of the Supreme Court. With this, we come to a conclusion of our today's discussion. We have seen the governor's power over the state bills. We have also examined the constitutional provisions in this regard, and we have also seen what the Honorable Supreme Court has observed in various cases. Now let us see a practice question for your prelims examination. So the question is, consider the following statements. Your statement number 1 is, it is mandatory for the governor to give his assent to a bill passed by the state legislature. Your statement number 2 is, Article 200 of the Constitution talks about giving of assent by the governor to the bills. Which of the following statements given above are correct? Your options are, option A is 1 only, option B is 2 only, option C is both 1 and 2, and option D is neither 1 nor 2. Kindly drop your answers in the comment box below. Now let us discuss a practice question for your mains examination. So the question is, the position of the governor is controversial in light of the emergence of cooperative federalism comment. So firstly, you will write that the governor is the constitutional head of the state under Article 153 of the Constitution. The post of the governor is mandatory for the state government. Then you will talk about how there is a cooperative federalism between the central government and the state government, and the governor is an important link between the central government and the state government. Then you will say that the governor is, a constitutional head of the state. So he should be working towards the, welfare of the state rather than, acting as a mere puppet in the hands of the central government. And definitely he should make sure that the governance in the state is carried out by following the constitution or by following the provisions of the constitution. And you will write the controversy that is happening and the everything which is happening as I have discussed in my discussion today. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you liked today's discussion and found this video to be helpful, kindly like our channel and subscribe to it for more such updates. Thank you.